It is not a good look when you have not one, but two deliberating jurors making statements to the press immediately following the SJC ruling that was made earlier today, saying yes, they in fact got it wrong. After serving as a juror in the Karen Read trial and seeing the chaos that has unfolded since, it is clear to me that the criminal justice system in Massachusetts needs some work. What a statement to be making 49 days before the next trial is supposed to take place. Hello, and welcome back, roommates, to Alexasrewm, where we are not lawyers, we are not medical professionals, we are not law enforcement, and no, we are not tow truck drivers. Despite my vast knowledge in trucking and towing and tow trucking, no, we are just people. People who have opinions. And sometimes, yes, those opinions involve tow truck driving and tow truck drivers and missing Sally port footage and dog ghosts and taillight pieces that like to magically reveal themselves and stop and shop bags and such. But that's not what we're talking about today. Today we're going to be shifting our opinions around this. Apparently 2 jurors had come forward today. This was only shared almost 2 hours ago, of another juror who had actually been in communications allegedly with Christina Rex since the trial, and they never wanted to come forward because they didn't feel comfortable sharing their statements until I guess they were clearly outraged by today's ruling. Yes, the SJC, meaning the highest court in the state of Massachusetts, did in fact deny Karen Read's motion to dismiss the counts 1 and 3 charges. So count 1 being the M2 charge and count 3 being the leaving a scene of personal injury and bodily harm, yada, yada, yada. This was after Beverly Canola Oil declared the mistrial back in July after jurors had sent multiple notes saying they were unable to reach a unanimous verdict. There was a lot of chitter chatter around whether or not the verdict slip was confusing or not confusing. Bev said she amended it. Who knows if it was actually amended, but it appeared that in the following weeks, following the mistrial declaration, that multiple jurors had come forward to Karen Read's team, as well as the prosecution, that they had agreed she should be unanimously, that Karen Read should be acquitted of the counts 1 and count 3 charges. And they were only split on the manslaughter charge by operating under the influence, which again, altogether, the charges just don't really make too much sense to me, and just stacking it all, I believe the M2 charge actually came later into the game anyways, so what a powerful statement to make following this ruling as a deliberating juror, because here we are, right, on the interwebs, screaming our freaking lungs out and saying this is absolutely ridiculous, but the SJC doesn't seem to have a problem with double jeopardy in the US of A, or at least in the state of Massachusetts. So, according to the Boston Globe, the state's highest court ruled that there was no serious issues with the declaration of last summer's mistrial in the Karen Read case, clearing one of the many hurdles ahead of her upcoming retrial, which is, we all know Bev has a hard-on for that April 1 start date. So Tuesday's ruling, the Supreme Court, a judicial court, declined to dismiss any charges or haul jurors back into answering questions about their deliberations, as Read's lawyers had sought. Read's legal team said they were considering appealing to a federal court. The statement was made later on today by Marty Weinberg, who is her appellate attorney. I'm sure they will. I'm sure they're going to go as high up the chain as they can with this, as they insisted their client's constitutional right against double jeopardy was violated. And what a way to make a statement, too, as well, if you're going to bring it to federal court. And again, I mean, as much as Bev has that hard on for that April 1 start date, I just don't see it happening with what the flurry of motions being filed back and forth between the defense. Today it was more heavily driven by the defense, but the Commonwealth has also been adding a lot of new pieces of discovery and entering that into the chat. So we will see, but this all sprung. So her attorneys filed an appeal to dismiss the 2 charges on which the jurors said they agreed. To retry her on those charges, Reed's team argued would be to violate her constitutional right against double jeopardy, the principle that someone cannot be charged twice for the same crime. In oral arguments before the SJC in November, her lawyers ultimately called for a more constrained approach to order Canola Oil, Beverly, to bring the jurors back in for a closed-door hearing to answer questions about whether there was a unanimous verdict internally. Because as we know, there were multiple jurors who tried to get in touch with not only the defense, but the prosecution as well, too, right? They were sending emails, they were ringing up Lally's phone, right? They were trying to set their story straight, too. And I can't imagine, the amount of guilt that some of them might even have, especially, with all of the new information, all of the new piecemeal video clips that have been just slowly making its way over, all this missing Sallyport video footage that's just magically revealed itself after 3 years of being in hiding. I mean, I would be absolutely outraged. I would feel guilty, exactly like this juror expressed earlier today to Christina Rex. And it's just funny to me because it's like this happened in November. It's February now. The trial's supposed to start on April Fool's Day. Joke's on all of us, right? And I just feel like it would have been so much quicker and easier and less paperwork if she had just said, yeah, let's just bring them in. 45 minutes probably would be all it would take. You're asking 3 questions, tops, to each of the deliberating jurors, right? Boom, 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 boom. Have a nice life. What did you vote for this count? What did you vote for this count? What did you vote for this count? Great. Awesome. Thank you so much for your service and your time. Have a nice life. And how simple and easy would that be? And it wouldn't make headlines like this report is today. And I can't say that it looks particularly good for our boy Hank Brennan, who is so afraid of that unaired interview that aired after the Super Bowl, after the floor. I thought the floor was like a segment. This is how out of touch I am with American television these days. The floor is, I guess, a reality show, a game show, or something on Fox. And then after the floor was only a small segment. It was only like a 6-minute clip from the actual full-length interview that ended up being aired last night with Ted Daniel. Karen Reed's sit down with Ted Daniel. He was shaking in his boots, so I can only imagine how he's gonna respond to this. I mean, what can you do? You can't really argue anything if jurors are allowed to come forward and speak to the press if they want to. So they go on to say, so this is the second juror that came forward. After serving as a juror in the Karen Reed trial and seeing the chaos that has unfolded since, it is clear to me that the criminal justice system in Massachusetts needs some work. Are you listening, Maura? Because it's us, Margaret. Despite being one of the most progressive states in the nation, so many aspects of our criminal process are antiquated, confusing, and need to be updated. I mean, seriously, what, if anything, am I freaking reading? It has to be dumbed down. The law needs to be easy for anybody to understand. You shouldn't have to have a law degree to understand how stuff in a courtroom works. You just shouldn't. Because any single one of us could be a defendant. Any single one of us could have a family member who is a defendant. Any single one of us could be called for jury duty. And so the more knowledgeable we are about how the justice system works and how the law works, the better equipped we are to protect ourselves and actually make the right decisions when we are deliberating and serving our duty as jurors. In this particular case, Bev went the extra mile to make these jury instructions extremely confusing. It's like, don't check a box if you can't come to a unanimous verdict on any of the counts. Okay, so does that mean, what if we acquit on these two things? Or what if we voted guilty on these two things? Would we then proceed? Would we then check boxes? I don't know. Or do we leave it blank? It's not that straightforward. It would not infringe on the role of the jury to require all trial judges to provide clear instructions that help jurors comprehend all aspects of the job that they are tasked with. Agreed. Absolutely. Like, one, what does reasonable doubt mean? What does it really mean if you have to try and figure out how John O'Keefe was hit by a car because the Commonwealth didn't do a good job of explaining that to you and the evidence that you're looking at doesn't add up or make frickin' sense, then it probably didn't happen. If you have to ask yourself, where's the crash report from the motor vehicle accident? It has to be reasonable doubt. Similarly, it would not intrude on the jury's function or the sanctity of the deliberative process to require a uniform process for delivering verdicts and verdict slips, particularly in cases involving multiple count indictments. So they're saying, because there was not only the 3 charges, but the lesser included charges, right? Making these kinds of changes to ensure criminal defendants receive a fair trial seems like the bare minimum our courts owe to those whose liberty is on the line. What a powerful, powerful statement. And that's the second one. That's the second one that came forward. And it's like, we don't know. We don't know what they decide, if they decided guilty or not guilty on the second charge. We don't know that. We don't know. They could have voted guilty. But this is the statement that the first one made. Not exactly surprised. An interesting situation whereby the truth that the jury was unanimously not guilty on 1 and 3, with multiple jurors signing affidavits swearing to that, and the legal process, there were affidavits, and the legal process ramifications of these facts coming to light after the mistrial was declared appear to be in conflict. SJC ruling, meaning the legal process trumps the truth. At the end of the day, there are lots of pieces to this blame pie from a process perspective, and we, the jury, definitely own a piece, maybe even the biggest, although we aren't exactly professional jurors and didn't know what we didn't know. By not making it clear in the jury note that we were only hung on charge 2, that was our mistake. We also didn't know that it would immediately lead to a mistrial at that point without any further interaction with the judge. Again, you don't know what you don't know, especially if it's your first time serving on a jury. Like, people just expect you to just get it. I mean, you don't step into a job day one and they just hang you a manual and they're like, go figure out how all of our software and systems and processes work. You usually get 2 weeks worth of training before you're actually sent out there and thrown to the wolves. And I feel like even after 10 weeks of serving on the jury, if it's still your first time, it's still your first time. And maybe you don't know maybe you don't know the proper etiquette. Maybe you don't know all of how to interpret all the information. I think they were allowed to take notes, but there were no readbacks. So you could be confusing your notes to mean something else. They might make sense in the moment when you're taking them, but then in a few weeks' time, 10 weeks' time, and you're like, who's Anthony Flamati again? What did he say? A simple clarifying question from the judge as part of any trial involving more than one count as to whether the jurors' findings of being hung are related to all counts would easily prevent the situation that has unfolded in this case. So they're pretty much echoing, or rather the second juror whose statement we read through first is pretty much echoing the same thing. Is like, I don't understand why Bev didn't ask. Why didn't she ask for further clarification? They wanted to speak up, but like, who wants to be the kid to raise their hand in class first, right? Like, I always hated that. I always hated, even if I knew the answer and I was confident that I knew the answer, right? I still didn't want to be the first one to raise my hand. So I imagine it's probably the same thing when it comes to being a member of the jury, right? Nobody wants to speak up. And Bev at that point had pretty much had it. Now, despite the ruling not going the way that we had all hoped it would, there is a light at the end of the tunnel, or in this case, a bat symbol, as Mark Betterow, yes, that Mark Betterow, who we have all been tuning in to watch his commentary on all of our favorite YouTube channels for pretty much throughout most of the Karen Read trial last year, has now officially entered the chat. This was filed earlier today by David Yannetti to add Mark Betterow to the team Pro Hoc Vice. So Mark Betterow is also currently serving as Aiden Carney, Turtle Boy's co-counsel. Some people are speculating whether or not this will be a conflict of interest. I don't know, but I do know that it's going to look intimidating AF when Karen Read rolls into court with like 5 lawyers at one table, and then you have special prosecutor Hank Breenan and sad boy Adam Lally tweedling his thumbs next to his paralegal Miss McLaughlin. So I this is like the super team. This is like the Avengers of lawyers, right? Like joining team Karen Read. And I feel like with all this stuff with Morrissey trying to pull those email communications he was sending out to his judge buddies on his iCloud account, I feel like this is a really, really smart move. I mean, the more smart brains you can put together in one room, the better. This is going to be incredibly interesting. I don't know exactly like what capacity he's going to be. It doesn't really explicitly say what he's going to be assisting with, but I imagine he's probably going to get in there. He's probably going to throw a couple rounds. So we will see, but I really can't wait for him to be in the courtroom and face to face with like Jen McCabe, Proctor, and even Bev. So that was some fun news. This motion we're going to go over tomorrow in tomorrow's video probably. This was the motion of reciprocal discovery filed by the defense. Apparently, Chip Proctor likes to send sweet nothings to ADA Lally after being a prosecution witness and being under internal affairs investigations pretty much immediately following your testimony, which was streamed on Court TV and Long Crime and Emily D. Baker, who's got like 800,000 freaking subscribers, and every other law tuber covering this, for sending disgusting text messages and texting your buddies about an open investigation who live out of state. And you're sliding into Lally's DMs and pretty much saying what you said to your buddies about how much you hate David Yannetti. It's not just David Yannetti, guys. He thinks Alan Jackson's an a-hole, and that's why he didn't watch his closing, which infers that he had been watching other parts of the trial. Now, there's a couple of really interesting points that they bring up in this motion. They also mention Jen McCabe, potential impeachment issues as well too. Lally coaching some of the witnesses, including John O'Keefe's niece and or nephew. Really fascinating stuff. More is definitely going to come down the pike. I mean, Karen Read had her interview, her sit down with to Daniel. So a lot has been cooking up in the world of Karen Read, and if you want to stay up to date with all of that and more, make sure you hit that subscribe button, make sure you hit the notification bell so you do not miss that next video drop like a hot mixtape from me, and make sure you hit that like button because that tells the YouTube algorithm and the SJC in the state of frickin' Massachusetts. See you in the next one. Bye.